Welcome to Riverside Center for Innovation Boost Your Business webinar series. My name is James Myers Jr. I'm the Director of Community and Business Development at RCI. Welcome to our Boost Your Business webinar series. Tonight, the topic will be joint venture, and our subject matter expert, even though he'll humbly, kind of disregard that, is Kyle Higgins. He comes to us from Reed Smith. He's going to answer a lot of your legal questions this evening. Please give him your undivided attention. We will record this session so you can go back and look at it, and we'll send it out to you as well. So I do want to be respectful of everybody's time, Cal's as well as the participants. So Cal, please feel free to take us away.
Thanks, James. First question, can you guys hear me?
Yes, we can hear you.
Okay, great. It's a good start. Yeah, so thanks for that introduction, James. Just to introduce myself, my name is Kyle Higgins. I'm a fourth-year associate at Reed Smith in Pittsburgh, and I do corporate and business law here. I've been working with James and RCI generally for a little over a year now, managing the intake of the RCI entrepreneurial clients that we get and work with through the partnership that Reed Smith has with RCI. I've loved working with RCI and James so far, and I'm happy to be here to talk about joint ventures. I'm not sure if the slides were circulated beforehand, but I will definitely bring them up and share my screen to do that. Just one second here. Okay, here we go. Yeah, so basically the idea here is that I have, some things that came to mind that I think are important to know from a joint venture perspective with legal considerations. The last presentation I did for the BizFit ended up being a lot of back and forth question and answer, which I'm happy to do that. I think that I'll move forward with this presentation. And if you guys have any questions, please feel free to interject. If you want to raise your hand or, send a question through the chat, I'd be happy to do that because it's more important for me to answer your questions, or at least try to, than it is to cover every single detail in this presentation. And if you do ask a question that I don't quite have the answer to right now, I'd be happy to look into it further for you and get back to you. But with that, I think we can go ahead and get started. So here's a high-level agenda, just talking about some broad strokes when it comes to joint ventures. We'll start with generally what they are and what purpose they serve, and then how they're structured. Some due diligence concerns with respect to joining a joint venture if you're considering it, what you or other joint venture parties could contribute to a joint venture, how they're governed, and then special considerations when it comes to scope and considering other opportunities for your business. So first, just talk about generally what a joint venture is. I apologize if I'm, covering things that you already know, but I think this initial part should, just serve as to set the stage for the rest of the presentation. But basically, we'll get into how exactly they're structured legally, but it's a collaboration, business collaboration between one or more parties. And, individuals can enter into joint ventures with each other, or legal entities. And a lot of times they're existing businesses that already have their own operations and history that want to, come together to form a new entity, or just have a contractual relationship to enter into a joint venture. And, the basic idea is that there's a common purpose that, for some reason, the joint venture participants would find it advantageous to work together on versus separately. Sometimes it's a specific project or the collaboration on projects, such as, a good example is if you are you're trying to offer, say you're working in the construction field or contracting, and you might have one joint venture participant that, say, is a general contractor and has relationship with a lot of customers, and then you have other participants that might have more specific expertise. But in order to, have more weight when bidding on projects, if you come to the table as a joint venture who can offer all, if you can offer several services to a client, then that's more appealing to them. Some other reasons for starting a joint venture would be to develop new technology. This is common in, for example, the pharmaceutical industry, or robotics, where it's going to take a lot of research and development, and parties want to spread the costs of those around in order to develop that new product, and they do it through a joint venture. And then also generally, it can just be used to start a new business or enter into a new field. And then another general point here is that one of the fundamental concepts of joint ventures is that you're sacrificing your control over your own business or how you operate in some aspect of it for some of the benefits of working with other parties. And we'll get into those benefits, I think, on the next slide. So, I talked about this a little bit on the last slide, but basically, some of the benefits of entering into a joint venture is that, one example is it spreads the costs and risks for large projects. So, if your company is considering, you'd like to, develop some sort of new technology or kind of, bid on bigger projects for clients, but you can't really afford to do that yourself, or you don't want to assume all the risks that would be associated with doing it on your own, then it could be in your interest to join up with somebody else to do that. Similarly, just access to new customers. You might enter into a joint venture with a company who is pretty well established in the field, and as a result, you can offer something to them, but they can also offer connections to you, and allow you to reap some of those benefits that you wouldn't otherwise be able to. And that kind of relates to the next 2 points: entry in a new market, or enhance the credibility. It's kind of all about, you are taking advantage of a relationship with another person or entity in a specific industry, and what having that connection with them can do to help you. And then also a final point is that, if you have a more robust setup with a joint venture, more capital and more operating power, and also just additional people with additional connections, this will allow you to expand your access to financing and investors, and increase interest there. So the kind of the threshold question here from a legal perspective for joint ventures is it going to be a contractual joint venture or an entity joint venture? And there's specific considerations for each, and throughout the rest of the presentation they come up in different ways, but I'll describe generally how they differ here. And I think for this group, contractual JVs would be of more relevance. Basically, contractual joint venture is governed just by one written agreement without forming a new legal entity, but it's just 2 or more parties, often called a strategic alliance agreement or joint development agreement, which is more specifically used if you're working together to engage in research and development, to develop a product or a technology or something. But a contractual JV, typically it'll have a specific term, which may be a certain number of years or until a specified project is completed. There's less legal documentation. with a contractual JV, because you don't have to, you know, do the kinds of documents that I'll explain, you know, the next bullet under entity JV. There's no filing fees because you don't have to form an entity. And generally this, you know, this is better for simpler joint ventures when it's really just businesses working together, providing their services to reach a common goal, as opposed to, you know, more complex joint ventures. And so for an entity JV, basically that's, you know, you are creating a new legal entity that has owners that are, you know, the joint venture participants are the owners of the new legal entity. So you might have three businesses that decide to form a joint venture, and they might form an LLC. Each of them has a third interest in it, and then they operate that joint venture for the specific JV purpose under that new legal entity. And, you know, as an entity, it may have an indefinite term and kind of just, you know, the entity survives forever, but it's a little bit more of a complex process because you have to do all the documentation to form the entity, to register with the state, to decide, you know, who owns what, and to document that ownership and also the rights vis-a-vis the joint venture members' ownerships. And there's also some fees that you have to pay when you form a new entity with the state. And as explained above, this is a little bit more, I think, more applicable for more complex joint ventures with kind of a longer timeline. So some more specific considerations when it comes to contractual JVs, which again, I think are more relevant for this group. One is the scope of the joint venture. So when you come together, you want to define the specific purpose of the JV and, you know, not have it too broad so that it unintentionally covers aspects of your business that you want to cover separately from the joint venture. And we can get into scope and how you address that with respect to your other business opportunities later in the presentation. And basically what, you know, a strategic alliance or joint collaboration agreement will set forth is, you know, each party promises to, it has certain obligations with respect to whatever the joint venture project is. So, you know, if you have, you know, if you're offering to, you know, build a house for somebody through a joint venture, you might have somebody who is in charge of all the plumbing, somebody else who, you know, for example, is in charge of heating and ventilation and air conditioning. And you kind of, you know, set forth which of those services each joint venture member is responsible for. And kind of what naturally entails from that is that you need to figure out who manages the joint venture and how decisions are made, and, you know, how each party works together to kind of decide, because obviously you're coming together to have one common interest, but each business has their own separate interests as well. And that will be covered later in the presentation on governance matters. Similarly, you know, you want to figure out who bears the cost. Typically, if it's, say, three service providers coming together to form a joint venture, typically each of them will bear their own costs. But, you know, there might be a situation where, say, there's one joint venture party who just has, you know, a lot more capital, and they're in a position to bear the cost, and that's kind of what they're bringing to the table with the joint venture. But all that, you know, needs to be set forth in the relevant agreement. And then you also have representations and warranties that each joint venture party will need to give in the joint venture agreement. And basically what rep and warranty is each party will state basically facts about its entity, or the person individually, to give the other parties assurance, that they're entering into an agreement with somebody that has relatively limited risk. An example would be, each party might need to represent a warrant that it doesn't have any outstanding indebtedness, or it doesn't have any outstanding litigation against it, or that the joint venture parties, none of them are party to another agreement that would prohibit them from engaging in the joint venture and the purpose defined in the agreement. And so that would be a natural part of a strategic alliance agreement. Another point is, kind of the allocation of liability, which is, as I said before, along with spreading costs, spreading liability is a benefit of joint ventures, and it allows you to, kind of only bear, to reap the benefits of the joint venture, but only bear your own liabilities. So, what an agreement, a JV agreement might say is that basically each party will indemnify, or basically saying that each party is liable for their own mistakes in the joint venture, so long as they're working in the purpose of the joint venture. And then you have term and termination. As I said before, a lot of times the contractual JV's term is limited to when a specific project is completed. But if you do enter into a JV to bid on multiple projects going forward, maybe you have an indefinite term and allow the parties to terminate the agreement whenever they agree to at some later date, or maybe you decide to do it for 5 years, and the agreement will terminate unless it's renewed by the parties. But those are all options that you can put forth in the agreement. And then another consideration is just dispute resolution, which I kind of cover a little bit later with respect to minority protections and deadlock advisors. But you need to, because you have competing interests in a joint venture, you're not, obviously you're on the same page with what your goal is from a business perspective, but you're going to have conflicts or disagreements on how you want to run the joint venture. And you need to consider, do you want to send those disputes to, a designated outside advisor who's independent, or do you want to have them go to mediation or arbitration? But those are all things to consider, and you want to have those accounted for in the agreement ahead of time, to allow you to save time and money in the future.
So Cal, I did want to mention a housekeeping rule to our participants. You must have your camera on. We're doing our best to kind of transition into digital citizens. I think the least you can do is have your camera on while you're participating. If you had an excuse and you sent it to me, I have it, but everybody else, please have your camera on.
Daddy Pig has reached the speaker. Or running has made it.
Cal, you can lead us away. Go ahead.
Okay, and then so the question is, assuming that you, instead of doing a contractual joint venture, which again, not to belabor the point, which I think contractual joint venture is probably more relevant for this group. But if you decide to go with an entity JV, you have to decide what entity to use. And there's some different options here. The most common are corporations and LLCs specifically because of their tax treatment. But I covered a little bit of this in my prior presentation, but I think that it would be good to cover it here as well. But basically, the corporation is owned by its shareholders, and it's run by a board of directors, and basically the joint venture participants would be shareholders, and corporation, LLC, limited partnership all protect the joint venture members from liability outside of what they contribute to the entity. I see a question here. Does Reed Smith provide strategic alliance agreements? Yes, we do. We do. We've drafted those before, and would be happy to help you work through one. But one point I would want to raise with that is, we would only, we're only able to represent the RCI client that comes to us. So, if you're considering entering into a joint venture with, one or more other businesses, we'd be happy to put together a draft of an agreement for you. But that would just come with the caveat that those other participants would need, or we'd recommend that they get their own counsel to advise them. And we would, really only be representing you guys. So yeah, and then we'll get in a little bit of the details on picking an entity in the coming slides. But so I've limited this to LLCs and corporations because of just they're more common in this regard. And as a theme that you'll see throughout this is that LLCs are just a little bit more flexible, which is why I would recommend them for if you choose to go with an entity JV. But so the way it works is the owners of the entity are going to be the JV participants, and then that's kind of the base, and then from there you have to decide how exactly it's run. But so for an LLC, the JV participants would be members of a limited liability company, and then they would be shareholders in a corporation. And then we can help with this, but you need to put together organizational documents that kind of govern the owner's rights and how the company operates. Some other points here, that you can create different equity restrictions if you'd like to, basically. But more of a focus here, I think, is better placed on taxes and the fact that if you're an LLC, you're only going to get taxed once as a member of an LLC in a joint venture. But if it's a corporation, and the entity JV corporation receives income, then you're responsible for your portion of that income tax. And then if there are any distributions from the corporation to the shareholders, then you'd be taxed on that again in your capacity as a shareholder. And then here, a couple other points. So this liability is a big piece here. So, basically the whole concept of limited liability is why you set up a legal entity if you're going to run a business. And, the same applies to if you're going to do a joint venture under a new legal entity. But the concept is if you have your own business and you want to enter into a joint venture to create a new entity, basically that any liability of the new JV entity, they can only recover from you whatever cash or assets you've contributed to the business. So to the joint venture. So if the joint venture gets sued, they can't come into your own separate business bank account and take money from there. And in terms of management, limited liability companies are flexible. They can be member managed, meaning that major decisions are just made by the owners, or you can make them managed by a board of managers, which is just a designated set of individuals that make the major decisions in the business. And that with a corporation, it's a little bit more strict. you need to have a board of directors, which is basically the equivalent of a board of managers. And then for LLCs too, but for corporations, you need to have officers, which are more of the, day-to-day executives running the business, like president, treasurer, secretary, things like that. So, another point to consider when it comes to joint ventures is, basically, in layman's terms, kind of figuring out what you're getting into. You can consider this due diligence being, confirming assumptions that you have about the other joint venture partners that you are entering into the JV with. Some of these assumptions might be, things that I mentioned before, like you might assume that the other joint venture partners, they don't have outstanding indebtedness, or they're not subject to litigation, or they're permitted by law and by other contracts to enter into the JV. But these are all things that, you're not going to know without asking. And obviously there are a lot, the business benefits of entering into the JV, because that's why you're considering it in the first place. But there are some other, risks from a legal perspective that are important to cover. And these considerations tie to the reps and warranties. So, as I talked before, you'll have reps and warranties in your joint venture agreement that say, that X company isn't a party to any litigation, or, X company does not have any outstanding indebtedness, or it's not a party to any other contract that would prohibit it from entering into this agreement. And so that gets you, kind of coverage there. So if a JV party signs an agreement and one of those reps or warranties isn't true, then the other JV partners would have a claim against that partner. But typically the way that this is, the way the diligence kind of goes is that you'll come up with a list of questions or confirmations for whoever you're entering into the JV with, kind of just generally known as a due diligence request list, and have them answer the questions, and you kind of just get satisfied with, what their answers are. And if they do present some risks, you might want, to beef up the representations and warranties around those risks. If you learn that there was some past credit card debt issue with another joint venture member, and they say that it's all covered, but you just have to take their word for it, maybe you want to add in some more reps and warranties from that joint venture member saying that they don't have any outstanding credit card debt, or they haven't within the past 3 years, or something like that, kind of to get more coverage. And then below here, just some examples of what some specific areas of investigation would be. Like, you want to know if you're entering into a JV with another LLC, you want to make sure that entity is legally in good standing in your jurisdiction, so that it can be a valid and enforceable contract they're party to. If they're providing a lot of equipment or inventory, you want to know about any liens that they have on any assets. If they have an outstanding bank loan, and the bank, if that JV participant doesn't pay their debts on time, the bank might have a right to take their assets, and you, as another JV participant, would want to know about that to assess the risk. Similar with any outstanding litigation. And then another point, from a business perspective, if you want to partner up with somebody because of the relationships that they have, with customers or suppliers or whatever, maybe you want to see some of the contracts they have with them, or otherwise kind of confirm that they're bringing to the table, what they say they are. So, another consideration for joint ventures at the outset is, and specifically relevant for entity joint ventures, is who's going to contribute what to the company. And a lot of times this is cash or other assets. Sometimes it can be services. But for contractual JVs, as I explained before, typically the participants will bear their own expenses. But if you form a new entity, you need to capitalize that entity and fund it so that it can operate. And that kind of goes back to, different JV partners have different things to offer. So you might enter into a JV with a company that has a lot of cash, and they can kind of offer that, or they have equipment or real estate that you want to take advantage of, or as I mentioned before, other intangible assets like customer lists. But all of these things can be used to kind of contribute their value to the JV, and also services can be a type of contribution. And then, if you're at a point where there is a third party who's interested in investing in the JV, then you can go ahead and induce an investment from them, which, might come at, if it's in the form of debt, then you would owe that back plus interest, but it's all part of the considerations. So please, feel free to ask any questions if you have any. I did, kind of build in a little bit more time because I was expecting, there would be a little bit of back and forth, but, I'll just keep going. I'm happy to talk about, anything else, of course. So, another point here is on governance, basically deciding, how do decisions get made with the JV. And this is pretty, important. It's kind of the main, it's a big, I wouldn't necessarily say risk, but it's a big consideration with, you think that you're going to join up with other businesses and everything, is going to go smoothly, but, you can't anticipate what kinds of disagreements are going to arise along the way. So, if you have three participants in a JV, there might be certain actions that you might agree that only require majority approval. That might, for example, maybe entering into a new project, or, some other lower level of expenditures. But there might be other items where you want supermajority or unanimous approval on the part of the joint venture members. An example of this would be, if you're part of a joint venture, and another JV participant is a company that does business, that has, let's say, so say that you're entering into a joint venture to complete construction projects, but another joint venture member is actually has a separate business that's real estate development or property ownership, where they would use those services. So you might want to have to make sure that you have unanimous approval of any projects that are offered to that connected business, so that there's not conflict of interest, and you want to make sure that all the terms and fees are agreed to in a fair way. And you might have, instead of the members themselves making these decisions, each member might designate an individual to sit on a board of managers for the joint venture, and that basically, you could decide to have those 3 or 5 or it might be an even number, but basically the decision that the board comes to, or those managers, then that'll be the joint venture decision. Okay, looks like a question.
Real quick, I was about to say, we did get a good question that came in. So Alice is asking, what is the best time to get this paperwork started in terms of the joint venture?
Yeah, that's a good question. I think, once you reach some certainty about, um, about wanting to get into the joint venture and you basically have an agreement with the other parties that you want to do it, then I think it's a good time to, involve some lawyers and figure out exactly how to document it. But, I don't think that, if you still haven't gone out to, other potential partners and gauge their interests, I don't think it's worth it to put together a full agreement and just, put it in front of them and say, what do you think? And it's definitely, based on your own business judgment, to see, kind of like what is the likelihood that we would be able to come to an agreement here. And then once you feel pretty good about that, you can go ahead and engage counsel to put it together for you and have it negotiated.
So Kyle, I don't know if you've seen our next question, but it was followed behind, should this be done before a sales agreement is signed?
Yeah, that's a good question. I guess so. So my question to that would be who's signing the sales agreement. So, okay. So I guess if you want to, I guess it depends, because if you want whatever your obligations are under that sales agreement to be obligations of a joint venture, and you want to work together with other people to meet those agreements, then you probably could do it beforehand. But if you're just kind of operating your business and the joint venture is something that you're working on a little bit more of the long term, then you can try to work out kind of transferring those obligations under that agreement to the joint venture. But it really also depends on what the sales agreement itself says and if that's permitted, because you might need to get the consent of whoever the counterparty is to that agreement to transfer your obligations to the joint venture.
Alice, did you unmute yourself? I know you said you were the person signing the sales agreement. Go ahead.
Thank you. Is it okay if it would be for a long term on many projects? Would it be better to do it case by case, just in case the relationship doesn't work out? But thus far, we do believe it will. But I don't want to jump ahead or put myself in the situations where we sign up for 2 years, and in that time frame we have 2 projects that we're supposed to work on, and there's some challenges there. I mean, I know everything can be negotiated, well, hopefully, depending on the person, but how do you approach that where you give yourself a little bit of wiggle room to have conversations if things unexpectedly come up and you want to try to work through it with that company?
Right.
And it may not say it in the agreement, but it's something that came up unexpectedly. How do you deal with that?
Right. Yeah, I mean, that makes sense. And, what you try to do with the agreement at the outset is, to contemplate the unexpected, but you can only do that so much. And what I think helps is, you can enter into an agreement with other joint venture partners and just kind of agree to, moving forward, we agree on projects in the future that we want to work on. And like each time we're considering a project, we will get together and, establish what our rights and obligations are with respect to each individual project. So, if you have a joint venture with one or more other partners, and and there is a project that you want to work on them with, or work with them on, excuse me, then, you can go ahead and do that, but then you can have the larger joint venture agreement say that if there's another project that comes up, you have to agree, to the terms of that, and to agree to do it at all. So it's kind of, you can do it on a project by project basis and decide, if one doesn't go so well, then, the next one, maybe you can decide to try to do on your own. But that it kind of, it raises an issue of, if that's the case, you want to have that explicitly mentioned in the larger JV agreement that you can do that, because other joint venture parties might want to have some sort of non-compete in the joint venture agreement saying that, within a certain scope, you're going to bring, you're not going to do any of these projects outside of the joint venture. But if that's not something that you agree to, then, you can make sure that's not included.
How do you protect yourself in this process as much as possible?
That is a great question, and definitely, one that that pretty much summarizes what we try to do. I think, you just try to think of, there's standard issues that come up, and it's kind of, it would be my job to put together a draft of an agreement and know the kinds of things that come up and ask you about these kinds of things up front. And then that way, we can account for them in the agreement and decide, how we're going to handle them in the future. And, that kind of gives you some flexibility, but also protection. And, other than that, it's, it's hard to say without the specific example. But, there's definitely, we can draft an agreement around, pretty much anything, as long as the other parties agree to it as well.
Thank you for that, Cal. We have Marcus with his hand raised, and then we're going to go to Dyson. So Marcus, feel free to unmute yourself.
Okay, sure.
All right, so I'm just trying to kind of prepare myself, because I think I'm going to end up coming across one of these situations where it's going to be like joint ventured. So, for example, they got like Granada Theater on the Hill. It's a big project or whatnot. And I think I'm going to be doing a little bit of the HVAC over there.
Okay.
We were talking about joint ventured or whatnot. So I never done it before, right? So.
Right.
In a situation like that, where it's a big project, but they'll probably just give me like a small portion or something. What would be expected of me as far as what do I bring forth? You know what I mean? Or what I have to write up an agreement and all that,
Yeah, no, it makes sense. I mean, I'm not sure, if you're maybe like more of a smaller participant in it, the other, joint venture members are, might have an idea of how exactly they want to do it. But basically all your obligations and expectations should be set forth in a written agreement before you do it. So if it's for one specific project, the joint venture can basically be the agreement can be, the scope of it can be that specific project. And a lot of times, you'll have like a schedule or an exhibit attached to the agreement, that'll say, X participant will perform the following services. And then it'll have a list for you. And then obviously, if you're involved in that and you sign the agreement, you want to make sure that it says what you want it to say on that schedule. And then, that's where we come in and we'll point you to that and tell you, review this and make sure that you agree with it. So I mean, so that, that's how that would be governed. And if you have concerns about, what they're expecting you to do, then we would account for that before you signed it.
That makes sense. So it almost makes me want to before I sign it, I might come down and review. I mean, we didn't get there yet or whatnot, but I'm anticipating it or whatnot. So if it does happen, I definitely will want some, just somebody to review it with me, just a little bit of counseling and, and able to go free and do it on my own. But I think I got least until I can do that. So
Yeah. Yeah, for sure. That's definitely something that we can do, that we've done in the past.
So I did want to get to Dyson's question, but before we get back into the presentation, Cal. So Dyson was asking, is there a bond to protect parties in a joint venture?
Yeah, so I'm not sure if you're,
So-
oh, go ahead.
So say the parties get together and the joint venture comes, and I complete my part of it, but he does not complete, or she does not complete their part
Right.
of what they need to do. Because now that puts the whole project in jeopardy.
Right.
So now
Yeah.
would you guys write up in the initial joint venture agreement, like sit down and come up with what your cost would be, like what your, not yours, I'm saying what the other person's or each party's portion of
Yeah.
what they, what I mean, so
Yeah,
my
like
portion
the-
could be 1,000, somebody else's portion could be 1,000.
Yeah, to basically to compensate you for your losses.
Right.
If they don't perform.
Or
Yeah.
or at least continue to have the money to complete the job,
Right. Right.
if something happens with them.
Yeah. So I mean, we can contemplate that in an agreement, and also, I mean, I think that this is, like a performance bond. It's kind of like insurance. It's kind of like an insurance question, and we can definitely provide an agreement that, that the parties have to agree to obtain some sort of performance bond for projects, to make sure that everybody's covered. So that's kind of like an intersection of the legal part of it and the insurance part of it. But I think that it's definitely, something to consider and something that we can cover, like high level in an agreement. But then I think it'd be kind of up to, the parties to go out and, secure a performance bond or insurance, from a provider.
Thank you.
Yeah, thank you for that, Cal. Does anybody have a question before we get back on the presentation? I know Cal said he allotted some time for Q&A to go back and forth. This would be a good time to ask questions while we have a break into action.
What causes them to go wrong? Is it like business partners, like egos or things like that? Have you seen your fair share go wrong, or have you seen them like pretty much work out?
Yeah, that's a good question. I mean, I think, so the kind of work that I do is contractual. So it's the parties initially coming together to an agreement. And frankly, I don't think I've been practicing enough to see a lot of conflicts down the road. But they definitely do arise. And I mean, from my experience, what would cause conflicts are sure interpersonal disputes, and just tension in decision making and how to run the joint venture, what projects to take, who gets to do what. But all of that stuff should be, accounted for in the agreement so that there is a specified way to handle that stuff. And if somebody's not happy about it, it's kind of just tough because you agreed to it at the outset. But part of our job is to simplify that, and account for things so that there's a clear answer at the time. But then obviously, a joint venture might not work out because one or more of the participants doesn't have any money, or their business itself is declining, or for whatever reason that they're unable to do what they said they would. And that's kind of just, more of a business concern. And what we would do to account for that in a joint venture agreement is to say that, if any of the members is unable to pay their debts as they're due, or if they have to file for bankruptcy, or or for whatever reason they're unable to perform their services for an extended period of time, then maybe the other parties have the right to kick them out or to just terminate the joint venture. So that's the kind of thing that we try to contemplate at the outset so that there can be a clear path when something like that does happen. But obviously, in the business world, no matter the legal protection you have, there just might not be enough money or enough commercial success. And we're not able to stop that, obviously, but we are able to help decide how to handle those situations when they do arise. So,
Thank you.
yep.
Yeah,
But
thank you.
we're almost at the hour mark. So if anybody has any additional questions right now, I'm happy to take them. I don't know. Otherwise, James, maybe now's a good time to take a 5-minute break.
So like y'all said, it would be a good time to ask you questions. If not, we will take a break at 6:56. Feel free to turn your camera off, mute your microphone, and we'll get back at 7:01. Unless anybody has a question, I do want to kind of keep that open. If not, we'll take a short break for 5 minutes. See you in a second.
So the last point I would cover here on governance for a contractual JV is that there really are no officers, because, and I think that this might have been a question ahead of time. How does a JV work with the role of a president, CEO, things like that. And I will get into how that does apply in the coming slides on entity JVs. But if it's a contractual JV and all you have is an agreement, a strategic alliance or a joint development agreement, and didn't form a new entity, then there are no specific officers for the JV because there's no entity for those officers to be a part of. So really, the decisions are reserved for either just the joint venture members themselves, or a designated set of individuals that the joint venture members appoint. But for an entity JV, the governance is it's the same as if there was a legal entity formed to start a new business. And I covered some of this in my prior presentation, and I think that it's good to cover again. But basically, if you're considering a corporation and LLC, that this is the way that general governance works. So shareholders have major decisions, meaning shareholders are the owners of a corporation, and in a joint venture, the shareholders would be the individual JV participants. But they hold the decision, the major decisions, like to if you wanted to sell the JV, sell your interest in it, or take out a major loan for the JV, or dissolve it or terminate it. Those kinds of decisions are reserved for the shareholders. And the board of directors is more kind of one level down, a little bit closer to the details, the general direction of the joint venture, and major decisions, maybe like what new projects to enter into, maybe decisions to tweak the strategy or the purpose of the joint venture. And the board of directors might be equally represented by each JV party. So if you have 3 businesses that are together as a joint venture in a corporation, each of those joint venture members might, designate one member of the board of directors to make the decisions there. And then that corporation will have officers as well. And those might be, some of the same individuals that are members of the board, but officers like a president, secretary, treasurer, CFO, CEO, they're more in charge of the day-to-day operations and completing the specific projects. But again, with sort of closely held businesses and then joint ventures that those closely held businesses are a part of, a lot of these shareholders, board members, officers, they might be the same people. and probably will be. And for an LLC, it's, you know, pretty much the same. Just, you know, the language used is a little bit different. Instead of shareholders, an LLC has members. And, you know, an LLC can be member managed, meaning that there is no board of managers designated to make decisions. It's just the, you know, whatever those decisions that the board might make, if it existed, those are instead just made by the members to simplify things. But they can also have a board of members, which would basically serve the same purpose as the board of directors of a corporation. And then, you know, by law, LLCs are not required to have officers, unlike corporations, but they can, in which case they would have the same sorts of responsibilities as those in corporations. Another key consideration when it comes to governments is, you know, how do you protect a joint venture member who, you know, doesn't hold 50% or more of joint venture interests, which, you know, it's quite common, you know, especially if you have 3 or 4 businesses working together, you might have a 1/3, 1/3, 1/3 split, or have 4 quarters. And you know, you might want to protect your interest and make sure that you're not, you know, you don't get ganged up on and kind of bossed around. And that's why there are, you know, specific, you know, if there are things that you're specifically concerned about as a minority member of the JV, you know, say, you know, like I said, for example, if the purpose of the joint venture is to, you know, work on construction projects, and another one of the joint venture members has a separate business that's real estate development or property ownership or something, you know, you might want to have a unanimous approval be required before they offer your joint venture services to their own outside business because of that conflict of interest. But that's just one small example. But all these things are, you know, you can be, and that's, you know, what would be known as a related party transaction. But all these things are items that we would, you know, want to consider at the outset and account for them in the joint venture agreement to make sure that, you know, you are protected in the way that you want to be. And then kind of, you know, related is if there's an even number of joint venture participants, obviously, if majority approval is required, it could be, it's very likely that, you know, if you have 4 JV participants, you could have 2 on either side of a decision. Or, you know, if it's the board of directors or the board of managers or some other designated committee to make a decision that's equally represented by the JV members, if it's a 2-2 split, then, you know, you don't know what to do. So that's why we need to, you know, if there is an even number of joint venture participants, we need to make sure that we account for the event of a deadlock. And a lot of times, you know, I think what, you know, a great way to do this, if there is some sort of outside individual or entity that can be appointed as basically the final decision maker in the event of a deadlock. And I think that's easier said than done because, you know, you first have to agree to who that deadlock advisor is. And everybody has their own interests, and, you know, everybody wants to, they want to pick somebody who they think will act in their best interest too. So, you know, I think that this could be a sticking point if you have an even number of JV participants, but we definitely want to try to figure it out when we do, when we put together the initial document before the JV is formed. So if this happens, you know who to go to. And then in other events, you know, you might want to send, you know, larger disputes, there's a question earlier about if one party fails to perform, how do you handle that? How do the other parties get compensated for the losses that they incur? Who owes what, or who owes who what amount of money, or how does that get resolved? And one option would be to have a provision in your joint venture agreement saying that those sorts of disputes, or bigger picture disputes, will be sent to a mediator or arbitration to try to keep the costs down. And then, as a last resort, if there's some major decision, that basically can't be made, then, we might want to work into the agreement that one or more of the parties has the option to terminate the joint venture. But, these are things that they're flexible, and, basically it's, we as lawyers have some knowledge of how these kinds of things work, and what the options are. But really, what we want to do is just whatever you agree to, as long as it seems sensible to us, representing you, we want to be able to put that in writing. So, we can do any number, any combination of these things, in order to get you what you want, as long as the other parties agree to it. And then, so this last point, is, I think, important to cover, because just because you're joining a joint venture, obviously does not mean that you're going to stop operating your separate business, or that you're giving that up forever. So really, we need to make sure that you agree and the other parties agree, and that it's explicitly defined in the document what the purpose of the JV is. Because you don't want, say, just to go back to my example of a construction related joint venture, if you provide plumbing services, but you provide it, to both residential and commercial properties, but in the joint venture, what it seems like the business deal is that the joint venture will work together to provide contracting services for commercial properties. You don't want your residential business to get picked up in that. You want to be able to keep doing that part of your business outside of the joint venture. So you want to make sure that the purpose of the JV is adequately defined in the document, and we might even put in, an explicit exception to say that so-and-so, regardless of whatever else is in this agreement, is not prohibited from continuing, the residential plumbing services business. And that's, a key consideration, because, what happens if the joint venture isn't going so well, but the other part of your business is, you want to be able to keep going with that. So, and that's something that might be negotiated. So questions may arise about, what kinds of things you want to be inside and outside of the scope of the joint venture. And then, so this third point, saying that you have to determine what you want to be presented to the joint venture and what can be pursued separately. So that, you might have an agreement that on one end of the spectrum, it can be, the joint venture only agrees to participate in the projects that it mutually agrees to, and then otherwise everybody else can do whatever they want. And that, that makes it simple. But you might be entering into a joint venture with somebody else because you want to be involved in like all the business that they have with one of their customers. And as a result of that, you don't want that other joint venture member to, not present opportunities that it has to the JV, because that's why you signed up to it in the first place. And kind of related to that point is, it's possible that the parties want to make sure that nobody in the joint venture, engages in any competitive behavior during the term of the joint venture, or, solicits customers, et cetera. So, you could have a non-compete where, nobody is allowed to participate, engage in the, contracting services for commercial jobs during the term of the joint venture. And, it could be in your interest to have that binding on other members, but it obviously is against your interest to have it binding on you as well. So that's kind of just something that needs to be figured out among the parties. And, another point is non-solicitation. So that would be, an agreement not to, because you're getting connected with these new businesses and people, you might get new connections to their connections. So, you might be exposed to their customers or suppliers, and they might not want you to basically take their business from them moving forward. And so, it might be that there's an agreement in the joint venture agreement not to solicit customers or suppliers of the other joint venture partners for a period of a year after the joint venture ends. And then the non-solicitation also can apply to employees and contractors too. So if you're working closely with another joint venture member, including some of their employees, it might be, in that other member's best interest to make sure that you don't try to steal their employee away from them and have them work for your business. So, that's another concern. And it kind of ties to just this whole aspect of it. Joint ventures can be complex because they provide a good opportunity, but, each party has its own interests, and you can help each other financially and economically, and you might be able to achieve things from a commercial perspective that you would not be able to otherwise, profit off of it and increase your own revenues. But there are a lot of other considerations here that you want to protect yourself. You might want to prohibit the behavior of other joint members. So it's kind of this tension between collaboration but also protection. It's self-interest along with the shared interests that basically we try to account for in the documents, and and we try to help you negotiate to decide really where does that balance lie across all the different issues. So that is most of what I had for the specific points I wanted to cover. Here is my contact information. I'm happy to take other questions at a later date, but also now if anybody has anything to raise with me regarding joint ventures, or even, we do have a good amount of time left, other aspects of corporate law or starting a business, I would definitely be happy to talk about those right now.
Thank you for that, Cal. I think we got our first question coming in from Dyson. Dyson, feel free to unmute yourself.
So what advice would you have for a smaller contractor looking to maybe do a joint venture with a larger contractor?
My advice would be, to work with us or, whoever your counsel is, to make sure that you have, the right protections and that, you can't be, that basically, you fight as much as you want to say, like, these are the things that require my approval that the joint venture can't do without me, even though I'm only, this small percentage owner, or this small percentage of, contribution to it. And I would also suggest, make sure that you are not promising to do anything that, that you can't do, or that you might not be able to do, or if you need to caveat it, make sure that, that's included in the agreement. But the main thing is just, if you're smaller, obviously you have less bargaining power. And if you have a chance to get some protections for yourself in writing up front, then we can help you with that. It's definitely something that I would recommend.
Thank you.
So thanks for that, Dyson. Good question, as well as thank you for providing that detailed information, Cal. We got our next hand raised by Alice. Feel free to unmute yourself, Alice.
Okay, thanks. My question would be, for myself, we have a LLC that is the business, and then with the business or multifamily units, phase 1, 2, etc. My question would be, tax-wise, what would you say would be the best direction for us to what's a good word? Protect our properties and to financially, during tax time, be okay. Does that make sense? Because right now we are LLC, but we have some time to change it, and it was recommended that we should not be a LLC. I forget the other name. It wasn't something that was common that I've heard of before. And since it's considered a passive income, it was shared that being an LLC wasn't the best way to go.
Yeah.
I want to know, what are your thoughts on that?
Yeah, that's a good question. And, unfortunately, tax is not really my area of expertise. And, I would say that I know that many real estate, holding companies, and real estate related companies in Pennsylvania are LLCs. And, from a legal liability perspective, then, that's definitely a good decision. And I hate giving this answer, but I think that would also be a good question for an accountant, or some other tax advisor, because, I'm not able to say exactly what would result in the best tax treatment. But I would say I know LLCs are common for that purpose. And I do also know that, somebody with some more tax knowledge would be able to give you an answer on that.
Just to make sure, even though the parent company has its own entity and each phase has its own entity, what is the best way to protect each entity if something were to happen to one of them?
So you're saying you have one parent company and you have multiple separate entities?
Yes, that'll be the case, yeah.
Yeah, well, I mean, it sounds like that, that is, if you have a separate legal entity set up for each individual business, and that the only way that they're connected is being owned by the same parent company, then, I mean, to me, it sounds like that you're set, because, that's the whole idea is that you want to, you form a new legal entity, and then that, that shields the liability, from that entity, if all the liabilities of that entity are only going to be the liabilities of that entity by itself, they can't go up to the parent company, and they definitely can't go, up to the parent company and over and down, for one of your subsidiaries, for one of your other subsidiaries. So I think, if you're operating multiple businesses, it sounds like you have done exactly what I would suggest, which would be to have them, be separate legal entities that to shield the liability of one from the rest of them. I see another.
Yeah,
one of your
I think she was
LLCs
making a statement, but
taxes.
go ahead,
Go
Cal.
ahead.
No, I think she was making a statement, Cheryl Darwin in the chat.
Right. Yeah, I believe that generally that's correct. Basically, what I said about corporations earlier, how they're taxed at basically two levels, the corporation level and then the shareholder level. That applies to C corporations. And if you make an election to be an S corp, then an S corp is taxed the same way as an LLC, meaning that it's what we call a pass-through entity. It's not taxed at the corporate level. It's only taxed once at the owner level. But there are certain requirements for being an S corp. I think, I believe that one of them is that the shareholders in an S corp have to be individuals. But yes, generally that is true.
So does anybody have any more questions for Cal this evening? I know if you may come up with something, feel free to fill out an application for pro bono legal consultation with RESA that can be found on our website. Cal, we actually had a pretty large group of people registered this evening, but what we do know about people in the construction energy industry, their hours can be, it could be kind of congested towards the evening.
Right.
Sometimes we've had more success hosting them at the top of the morning. So it depends on what you're open to, Cal. We did record this session, but I'll follow up with you just in case we have some ideas about presenting again at the top of the morning.
Okay. Yeah, sounds good. Just let me know if you want to connect on that.
Sure.
I'd be happy to talk.
And thank you for your time this evening, Cal. You brought a lot of great insight into the legal manners looking into a joint venture. I know we had some questions from the audience, but they'll probably have some follow-up questions for you as well. So please feel free to take note of Cal's contact information. I also will get the slides to everybody that registered and participated this evening. Any last comments, concerns, remarks from the audience? Cal, would you like to close us out?
Yeah, sure. I would just say, thanks again to everybody, and thanks for the great questions. I'm happy to be in this role and answer any more questions that you might have, and look forward to hopefully talking to all of you again in the future.
Thank you again, Cal. For everybody participating on this night's Zoom conference, our Boost Your Business webinar series hosted by Riverside Center for Innovation and titled our Joint Venture Workshop. Thank you for coming. Thank you for participating. We'll be following up with the PowerPoint presentation. And I know we ran up, well, this is our normal time in terms of hosting evening workshops, but our RCI creed is make sure you practice safety first, safety second, safety third. When in doubt, go back to the first one. Please feel free to reach out to me if you have any additional questions. Have a good evening and look forward to staying engaged with you and keeping in contact. Take care.